Good afternoon, everyone. My name is Olly, Business Advisor here at Retail NZ. Hope you can all hear me. Welcome to the Employment Law Changes of 2019 webinar. Questions will be answered at the end via the chat function. Okay, here we go. Okay, back a bit. So the recent Employment Relations Amendment Bill has obviously caused somewhat of a stir lately, generating a lot of media discourse, and will no doubt have a major effect on some retailers. The main changes we'll be going over today will be obviously the minimum wage increase, the reinstatement of legislated rest and meal breaks, and the 90-day trial restrictions. It will obviously understandably be a confusing time for both employers and employees. That's why we've decided to put this broadcast out and break it down to help guide you through the process in a more practical sense. Firstly, so the 90-day trial, the ins and outs. As of the 6th of May 2019, the 90-day trial will be restricted to small to medium-sized employers only. So the legislation defines a small to medium-sized employer as someone who employs fewer than 20 employees at the time the parties enter into an employment agreement. So the wording there is key. So if you're wanting to employ a new employee on a 90-day trial, then you have to make sure at the time that agreement is signed on the dotted line that you have no more than 20 employees on the books. So an employer can be also a legal entity, such as a franchisee or a subsidiary of the parent company. So as long as you meet the standards at the time the agreement is signed, you can employ more than 20 employees further down the line. Of course, it goes without saying you won't be able to repeatedly use the 90-day trial from that point, unless, of course, you restructure or employees move on, thus lessening the numbers in your workforce. So as per normal, it's crucial that employment agreements are signed before an employee commences work. A few people have been stung by that before, I'm sure. So what if you have more than 20 employees? So if you are a larger employer with greater than 20 employees, the bottom line is you'll not be able to have a 90-day trial period within your employment agreement once the changes take effect. So there are two major workarounds that we've devised. The first one is a more robust recruitment process. So a lot of the time a nasty dismissal situation can occur all because an employer has rushed into employing the wrong person or has followed quite a quick recruitment process with little to no background checks. Maybe they didn't go over the CV as quickly, they didn't ask the right questions at an interview. All of these things can attribute to attracting the wrong person for the job. So it's important to get a sound structure in place and adopt that across the board for whatever position you're recruiting. If you don't have a 90-day trial to fall back on, it's important that we can provide some guidance and support for the pre-employment stage as well. Second point of order would be the probationary period. So obviously, contrary to popular belief, a probationary period is substantially different to a 90-day trial period. Basically, a probationary period is a clause within the contract that is related to performance expectations, or simply put, a clause which places an employee under further scrutiny for a period of time. It can be for any amount, provided that it's reasonable, and basically lays out the framework for what you are to expect from your employees and what they are to expect from you. During that probationary period, you need to set some checklists for what the employee is to accomplish, and when you likely meet with them during that period of time. So it's largely a give and take process. So let's summarize. 90-day trial periods are going to be restricted to small to medium-sized employers employing fewer than 20 employees. All other 90-day trial technicalities still stand. So the main one is the contract must be signed before the employee starts. They have to be a new employee, so they can't have worked for you as an employee previously. And it must be negotiated in good faith, meaning you can't force an employee into a 90-day trial period. Probationary periods are probably going to be the most useful workaround for this. You can, of course, still continue to use them to assess the employee's skills against the role's responsibilities. It's important to note as well that a probationary period can be applied retrospectively. So if you've just employed someone with no real protection, and let's just say they are to undertake a different task or even a different role, but still in the same company or still employed by you, you can therefore negotiate a probationary period just to, I guess, ease the confusion or ease any uncertainty that you may have when they're undertaking new tasks. Basically, probationary lays out a fair process for managing issues and ending employment if those issues aren't resolved. Unlike the 90-day trial period, however, the probationary period does not give you the same protection from an unjustified dismissal claim. It can, however, strengthen your case if an employee sort of pushes one, and lessens the damage should one be included in the contract. Last point of order, a good recruitment process is essential. You do not want to regret hiring someone. Okay, rest and meal breaks. I'm sure this is the one that many of you will be eager to find out a bit more about on. So one of the big talking points with the upcoming changes is the reinstatement of legislated rest and meal breaks. Currently, there are no restrictions on when breaks are to be taken. Basically, all the law says at the moment is an employee is to get them, whatever they may be, is purely contractual, or if they can't get them, then compensation must be put forward instead. So the new law changes take us back to as recently as 2015, where there was still some regulation involved back then. So as they are quite confusing, the amendment bill is quite detailed and confusing to read. We've taken some time to break it down and make it all easier. Okay, so the law has basically set out a schedule for an employee's entitlement to rest and meal breaks and how long these are to be. So the schedule is based on what the legislation defines as work periods, basically increasing at 2-hour intervals. So the following table should highlight it here. So if an employee is employed for a sort of 0 to 2 hour shift, there's understandably no entitlement. 2 to 4 hour shift, they're entitled to 1 10-minute rest break, which is paid. 4 to 6 hours, that's 1 10-minute rest break paid, and 1 30-minute meal break, which is unpaid. And the stock standard 6 to 8 hour shift will result in the employee getting 2 10-minute rest breaks, which are paid, and 1 30-minute meal break, which is unpaid. If on the occasion an employee has to work above and beyond the standard 8-hour day, then it simply just reverts back to as though the employee has just commenced a new shift, starting back to that 0 to 2 hour time slot. Okay, so now what? With the law establishing the minimum requirements for the duration and frequency of rest and meal breaks, it's important to note that you still have the ability to determine when these are to be taken. So this can be set out in an employment agreement, a roster, or other similar system, provided that there is always an agreement in place, meaning there is no law, there will be no law to say, provided there is an agreement, to say that you must take a break at this time. That is still a contractual matter. That's a very important point. So in implementing the rest and meal breaks, it will result in some rejigging and maybe some rehashing of things. You'll need to take into account what a day looks like for your business, because it's going to be different across the board, and how this will impact the provision of rest and meal breaks. For example, retailers who provide lunch or are in more of the food and drink industry, it would be silly to have a large majority of your employees all taking a lunch break at the same time, around 12 to 1 o'clock period. You could have this earlier, or you could delay it, provided there's always an agreement. Obviously, leading on from that point, you need to consider the busiest periods of the day and how many staff would realistically be needed at any given time. Ideally, although there's no definitive guidance on this, but ideally, common sense would dictate a meal break should give an employee a chance to grab some food and tend to any personal matters. You should look to cater for that. That's why it's unpaid. They can physically have that time to leave the shop, and it's largely unpaid time off work to an extent. It has no bearing on the employment. The only thing is that they are restricted to the time frame in which you specify. A rest break has benefit for both parties. It provides an employee with a quick refresher and ultimately increases well-being and operational performance. That's why the law says it's to be paid. The large majority of the time, employees wouldn't be able to leave the workplace. That's why there's that restriction there. So what if you don't agree? So if there's no agreement in place, or if there is a dispute, then it reverts back to what the law sets out as legislated timeframes. So again, the vast majority of the employment law, as I'm sure you're all aware, is centered around the parties acting in good faith. So basically coming to a logical agreement between one another. Rest and meal breaks are no different. However, in the absence of the agreement, the legislation proposed clear requirements for when these are to be taken. So someone working 9 to 5, for example, would observe the rest and meal breaks basically in the middle of those specified work periods. So as you can see here, I've put someone starting at 9 a.m. They will then commence their first rest break, so their morning tea or smoko, at 11 a.m. That's exactly 2 hours after they commence their shift. That will go for 10 minutes, and that's paid. They then have another 2-hour interval, so that's at 1:10 to 1:40. Again, a 2-hour interval as well, and that's unpaid. That takes them to 1:40. Their next afternoon break, or afternoon tea, if you will be 2 hours from that point to be taken at 3:40. They then have a 1 hour and 10 minutes left of their 9 to 5 day. So that totals up 8 hours and 7.5 hours paid. That is largely similar to the old laws of every 2 hours you must get a rest or meal break. However, that only occurs if there isn't an agreement. So it's important to have an agreement. That's a key. So let's summarize. Employees are all entitled to rest and meal breaks if they work 2 hours or more. There are only a select few industries that are exempt, none of which are retail. So those are your oil and gas industries and your essential services. Rest breaks are 10 minutes and paid, whereas meal breaks are 30 minutes and unpaid. The timing of these breaks are to be agreed upon between the parties, provided that they are getting what they're entitled to in terms of the amount and at least the minimum duration. In the absence of the agreement, the legislation proposes that rest and meal breaks are to be taken pretty much bang in the middle of the applicable work periods. It's important to note that rest and meal breaks are an important part of health and safety compliance as well as the employment side of things. And the employee must get the rest and meal break as far as reasonably practicable. You no longer have the ability to contract out of the provisions for extra pay or time off in lieu. Okay, moving on to the minimum wage increase and what this means for you as retailers. So April the 1st of this year, we'll see the largest minimum wage increase in quite some time. I think it's probably the largest in about 10 to 15 years, with $17.70 soon to become the legal minimum. It's a $1 increase from the current rates. So that basically means that all workers currently under $17.70 will need a pay increase by 1st of April. A couple of you, I'm aware, are already doing that, which is great in terms of compliance. However, you can wait until pretty much midnight on the 1st of April if you wish to. There are, of course, the exceptions of starting out and training wage workers. Their wage will remain at 80% of a full adult minimum wage. So that would bring them up as well to $14.16. So, of course, as this is a variation to an employer's employment agreement, you'll need to put a variation letter to the employees and make the appropriate change. That's just basically a paperwork HR sort of thing, just to ensure that there are no discrepancies as to when the change took place. It's also to ensure that you're complying with contractual laws as well. There are, of course, going to be more fundamental issues around existing, perhaps more senior and more experienced staff members who are already being paid perhaps above minimum wage. So those who are maybe on $17.50 or even $18, and therefore the pay gap may close significantly with them. So one workaround that we've sort of devised and we've seen quite popular and across a number of industries is to remember in this case that money isn't everything to some employees. Flexible working hours, discounts and out of work activities all have benefit to an employee who do not necessarily inflate your wage bill. So the law doesn't require you to put up an employee's wage just because workers under them are getting put up to minimum wage. They can possibly claim that they feel as though that they're disadvantaged and they're wanting to demand a pay rise, but you don't necessarily have to do that. There are workarounds, there are alternatives. Something as simple as cheaper car parking or extra benefits to recognise their length of service. These are all useful things. Sort of following on for that, if the business can't afford it, there are, of course, going to be businesses who can actually take the hit, the initial hit, but eventually in the long run, it will come out in the wash. So you can directly pass on the increased operating costs to customers through price increases, but again, this runs a risk that you will lose business. So in thinking about the price increases, it's important to keep an eye out on what your competitors' prices are, so what they are perhaps maybe paying their staff members as well, and assess whether this impacts your sales and profitability also. As I said previously, we do have some more comprehensive strategies specifically for that, myself and Emily, to help you through that. So get in touch in the coming weeks if you wish. Okay, Domestic Violence Victims Protection Act of 2018. It's something that has largely slipped under a number of people's radar. It's obviously hopefully not as wide encompassing as the other minimum standards increases, but it's certainly something to touch on because you never know. This change will also take effect on the 1st of April, and we'll see the implementation of the Domestic Violence Victims Protection Act. So, yeah, as I said before, it's not going to be as wide encompassing, but it's important to be aware of it if a situation ever warrants its use. So the purpose of the Act is to basically break down taboos and stigmatisation around victims of domestic violence. It aims to provide protection around time off from work and aims to combat discrimination within the workplace. There have been some research papers and some statistics done on this to say that domestic violence victims do often suffer a causal effect in the workplace as a result of their personal situation at home. To reduce the impact of that, the Act is essentially split into 3 key parts. So that's the ability to request a specific domestic violence related flexible working arrangement. Secondly, an employer would also be entitled to 10 days of paid leave, and also it introduces a new ground for a personal grievance claim. So we're touching on the 3 key sections next. So part 1 will be the flexible working arrangements. So the principle behind the request for a flexible working arrangement is to simply request a short term, it can be no longer than 2 months, variation of the employer's working arrangement. So the arrangement will look to assist in dealing with the effects of domestic violence, and it's largely similar to the usual laws around flexible working arrangements, which most of you may already be aware of. You can, of course, refuse the request, but only on the certain grounds for refusal. If an employee requests that, you as the employer have a duty to deal with the request as soon as possible, but no later than 10 working days after receiving the request. A key area or a key issue for me would be you can expect your employee to be somewhat uncomfortable about raising the issue. So the overarching concept of good faith should be stressed here. Exercising the employee's right to privacy around this particular issue, or if the situation ever arises, is key. Another sort of interesting point that the Act mentions is that the employee will have an expectation to supply proof of their domestic violence issue. Another quite contentious topic of that as well. So that's only if it's asked for it, if they're asked for it, of course. So that could be something like a medical certificate, a police report, court order, or any other applicable documentation. You must ask for this proof as soon as possible, but no later than 3 days after receiving the request for the initial arrangement. So after the employer has been asked to supply the proof, they have 10 days to supply the information commencing from the initial request. That basically reflects the concept of immediacy. So if you want some proof, or even if you have some doubts, or you just simply want to dot your I's and cross your T's, ask for a proof as soon as possible to avoid any confusion. Okay, part 2. So that's the paid leave component for those affected by domestic violence. Now this is where it gets slightly interesting. So the second part of the Act provides up to 10 days of paid leave, separate from annual leave, sick leave, bereavement leave. It's leave unto itself. So, and that's for those affected by domestic violence. So to qualify for this, employees must establish 6 months of continuous service with the same employer. It's exactly a carbon copy to the eligibility criteria for sick and bereavement leave. So the payment for domestic violence leave is paid again at relevant daily pay, the same pay formula you'd use for, again, sick and bereavement leave and public and alternate holidays or days in lieu. Of course, relevant daily pay, simply put, is the pay in which an employee would have received had they been at work on that day. So again, like sick leave and similar to the privacy and I guess HR issues around that, you can make payment for domestic violence leave conditional on an employee providing the proof. They have to provide the proof as soon as possible or as soon as reasonably practicable, exactly similar to the concept of sick leave. So an employee cannot carry over domestic violence leave into a subsequent 12-month period. That's common sense. It goes without saying that you can't accrue and carry over. That would be ridiculous. As this leave would serve a particular purpose, it of course need not be paid out upon cessation of employment, meaning because it's for a specific reason, there is no entitlement to have it paid out upon the end of employment. Okay, so part 3. This is something which may raise some concern, particularly if a domestic violence situation is handled in the wrong way. So, bottom line, it will be specifically unlawful under both the Human Rights Act and the Employment Relations Act to treat an employee adversely due to them being affected by domestic violence. Now, an example of this, which I've encountered previously, was an employee who had visible bruises on their face due to being affected by domestic violence, and instead of the employer dealing with it appropriately, they took the employee out the back and made them work out back on lesser hours, and they were subsequently at a disadvantage. The employee took them to the cleaners and they got compensation for hurt and humiliation and all the rest of it. That's why it's important to make sure that you handle the situation in the right way, no more so than now when this Act comes into play. So an employee has 3 legal options to address the issue. A personal grievance claim for an unjustified disadvantage, so if you reduce their hours or if you change their job role or if you remove them from a front of house sort of situation. A personal grievance claim for discrimination, and or a complaint to the Human Rights Commission. The Human Rights Commission would be totally separate from the employment path. So again, like most discrimination cases, it's one or the other. Of course, for the large majority of you, in fact, for 99.99% of you, the likelihood of these occurring are very slim. However, it's important to be careful in how you approach things. You don't want to accidentally say the wrong thing or disclose wrong information to the wrong people. So if you're ever faced with an employee who is a victim of domestic violence, it's important to treat the situation with a more heightened degree of sensitivity. So one key issue, again, sort of recapping the problems around this situation, apart from the added leave liability, which the Act is silent on, is the issue of privacy. So there is an assumption that the legislation will fall under the existing privacy laws, However, it may be a good idea to start planning a system for how do you approach the topic itself, or how you approach addressing the change in the workplace, and even more specifically, how an employee goes about requesting these different things. Every employer is different. Some businesses may have a general group chat or on Facebook where an employee can just simply say, "I'm not coming into work today." That would obviously not apply in this case. Therefore, you need to adopt some certain systems in your workplace to cater for that. You may also wish to consider engaging with services of EAP support, which we offer now as one of our partners. So that can help assist the issues in the workplace as well, and provide some extra protection for the employee, not just limited to what the Act provides as well. So obviously an employee is going to be uneasy at the time that they're raising the concerns, so you need to acknowledge that and really make sure that they're getting all the support that they need, within reason, of course. Okay, some union-related matters, bit boring, but we'll go through it. Just some key points. So for the vast majority of you, these changes may not be particularly relevant. Many of which have already come into effect last year on December the 12th. So some changes to be made aware of: if there are collective employment agreements or union representatives running through your workplace, particularly obviously you larger retailers. So pay deductions, they can no longer be made for partial strikes. So a partial strike is essentially low-level industrial action. It's not necessarily walking out on the job, but it's something it's a concept of protest. So that could be wearing a t-shirt instead of a shirt, not using a computer, standing up and not using a chair, etc. Just things like that you can no longer deduct from wages for. Businesses must now have to enter into negotiations with a multi-employer collective agreement if asked to by a union. So a multi-employer collective is where there are at least two employers and a union involved in the agreement. For example, a lot of meat industries, a lot of meat processing plants engage in those. So let's just say meat processing in Invercargill, and there's a meat processing in Auckland. There's a union that run through them both, and the union wanted to enter into a collective. However, you can refuse the initial negotiation process, but only on reasonable grounds. So we'll use the Auckland and Invercargill one. So obviously, it may be reasonable for one employer to refuse the negotiations if there are distinct, obviously, geographical differences. So more specifically, wages and the cost of living are much higher in Auckland as opposed to Invercargill. Why should an employer in Invercargill agree to the same rate of pay for their employees in Invercargill as the employees in Auckland? It wouldn't make any sense. Therefore, they can refuse those negotiations based on those reasonable grounds. Okay. Related matters continued. So employees will now have extended protection in regard to union membership discrimination. So that doesn't necessarily just apply to employees on a collective. It could be something. For employees who have engaged in union membership or union representation. From now, an employee's behaviour can be seen as discriminatory if it occurs within 18 months of employees undertaking union activities. So that's an extension from the 6 months. Union reps can now enter workplaces without consent, provided that the employees are covered under or bargaining towards a collective agreement. So if an employer just decides that they needed some representation and just automatically joined a union, then the union rep just can't enter without consent. It has to be for a specific purpose. Of course, union reps must be respectful of normal operating hours and follow health and safety procedures as well. Employers have a duty to disclose applicable information in respect to a union. So that's only if there's one that runs through the workplace again, so a collective agreement. The union, of course, will have to foot the bill for any publication costs, and the employers will have no expectation or obligation to pay for anything like that. Okay, so the 30-day rule will be restored. This means that for the first 30 days, new employees must be employed under terms consistent with the collective agreement. So the employer and employee may agree to more favourable terms from the collective, and then after the expiry of that 30 days, the employee can decide whether they want to stay on the collective and therefore be a part of a union, or sign the individual one and flag the union membership altogether. Okay, so yeah, obviously that's quite a bit of detail and a bit of jargon involved there. I tried to break it down as much as I could, but a lot of it, to be perfectly frank, does not necessarily apply to most of our members. However, for those that it does and are wanting a bit more in-depth information on the union-based law changes, feel free to give me a call and I'll be able to guide you through that more specifically. Okay, another key issue that's been at the forefront of a lot of people's minds is the government's Fair Pay Working Group and the Fair Pay Agenda. So they've essentially proposed a return to 1970s wharfy-style collective bargaining. Obviously, labour intensified, and collective agreements will apply to all workers across a sector, regardless of whether employees are officially unionised. So it's essentially unionisation without unionisation, and it's particularly covert in its approach. It's of course yet to become law, and understandably, Retail NZ is working actively to lobby against the proposal. So when some more announcements become apparent in the media or from MB, we will of course keep you posted. Okay, so just to recap, the large majority of you will already be complying with the legislation once it takes effect, to be perfectly honest. However, for those of you who need to make a few tweaks and changes, it's important not to get too stressed about it. For example, some of your stores have sole charge employees. I'm sure that's a key question many of you have anyway. So it may not necessarily be reasonable and practical for the employee to take a full half-hour meal break and close the store. The law doesn't necessarily expect you to do that. So for that, you could allow the option to sit somewhere close in the store, have their lunch out back, but still have an expectation to serve customers if need be. As their meal break is restricted somewhat, you could elect to pay them right through to offset this, provide some sort of voucher or other compensation as well. It's what is reasonable and practical in the circumstances. A rest and meal break for some industries is totally different to others. Okay, the 90-day trial period at this stage, and even following on from the law changes, is still some of your guys' friends. So although there are always going to be a couple of pitfalls to be aware of and technicalities, if you have fewer than 20 employees, it should be business as usual to keep in clause in your contracts. So for the larger retailers, if you don't have the luxury of the 90-day trial period, the key focus would be a robust probationary period if necessary, and an equally comprehensive recruitment system. As the minimum wage increase is going to be a complex issue, not solely just to put minimum wage workers up, but also has wider impacts to customers, as well as your image as a brand, as well as potential redundancies and restructures, please be sure to contact us for support and we'll guide you through that more specifically. Okay, now it's time for some questions if need be. Okay, so I've got a question from Marie. Is the 10 days paid leave on top of the 5 sick days? Yes, it is. It's totally separate entitlement to all other leave. Okay, can 30-minute meal breaks by agreement with staff not be taken? The answer is no. they have to be taken. However, you can impose some restrictions as to what a rest and meal break, or what a meal break looks like. Okay, so another frequently asked question, and one of it I've got here, is what if I have 22 staff at the time of a 90-day trial issue, but a couple of them are casual employees? So you need to make sure that the time that the parties enter into the agreement, that there are fewer than 20 employees employed. Bearing in mind, a casual employee is largely defined, or a genuine casual employee is largely defined as someone who works intermittent and irregular hours, and each new offer and acceptance of a casual shift is regarded as a new period of employment. For example, you need to make sure that you haven't offered, nor has a casual worker accepted, a new casual arrangement, because they would be classed as an employee at the time of the agreement. Okay, regarding probationary periods and contracts, how detailed does the framework need to be in the contract, or can we keep it high level? Yeah, largely that's contractual. There's no set criteria for how it should be detailed. It should be solely down to the position itself and what you'd expect from them in that position. You can set sort of regular timeframes in that clause for when you'll meet them, or even specific duties that you'd like them to perform within that time frame. It's purely by negotiation and by agreement, provided that it's fair and there's an expectation for both parties. So does the 90 days stand if contract is signed before the 6th of March? Yes, it will. Any contracts entered into prior to then will take precedent, even if the law changes overlap. Can we get a template for an amendment to existing contracts to cover these changes? Yes, we've got that available. That will be sent out. Okay, guys, I can see I've had a couple of changes. A couple of questions are still reeling in. So what I'll have to do is take note of those and record those down and come back to you individually within the next few hours, if that's okay with you. So I'm going to have to call it there and wrap it up. But thank you very much for being a part of it, and best of luck for you and your businesses.